Welcome to the Law GH channel and welcome to our 14th episode on the law of tort. In today's episode, we are treating negligence in relation to chattels, which is in other words called negligence in relation to manufacturer's liability. Let's begin by highlighting the position of the old law, which could be found in Heaven and Pender per Cotton, then Dominion Natural Gas and Collins per Denning. These two cases state the old principle to be that a manufacturer must take reasonable care to avoid danger from the chattel and warn the person who comes in contact with the chattel. However, the new law position stated by Lord Atkin in Donoghue and Stevenson is a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him, with no reasonable possibility of intermediate examination and with the knowledge that the absence of reasonable care in the preparation or putting up with the products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. From this principle by Lord Atkin, let's now look at the elements seriatim. 1. Manufacturer. Manufacturer includes repairers, masons, designers, assemblers, and even suppliers of articles. In Brown and Cotterill, the defendant, a mason, negligently erected a tombstone, and as a result, it fell on the plaintiff, who was lawfully in the churchyard. It was held that he was a manufacturer and therefore liable. It is necessary to know that manufacturers will not apply to retailers except second-hand car dealers. 2. Products. Products include things used externally and internally. In Grant and Australian Knitting Mills, the plaintiff contracted dermatitis through wearing woolen underpants which had been manufactured by the defendant. The disease was caused by the excess sulfides negligently left in the underpants by the defendant. Lord Wright held that the defendant was liable as no logical distinction could be drawn between a noxious thing taken internally and a noxious thing applied externally. He further stated that it was argued, but not perhaps very strongly, that Donoghue's case 1 was a case of food or drink to be consumed internally, whereas the pants here were to be worn externally. No distinction, however, can be logically drawn for this purpose between a noxious thing taken internally and a noxious thing applied externally. The garments were made to be worn next to the skin. Indeed, Lord Atkin 1 specifically puts as examples of what is covered by the principle he is enunciating things operating externally, such as an ointment, a soap, a cleaning fluid, or cleaning powder. 3. Sale of products. The sale of products is not limited to items given in exchange for consideration, but also items such as free samples. See Lord Denning's decision in Hawkins and Coulson and Perley UDC. Denning further stated that it does not matter whether the service or product was given freely or sold. Suppose that the manufacturer of a special soup sent out samples by way of gifts to members of the public, and owing to negligence in manufacture, a user of the soap suffers from dermatitis. Surely there is a cause of action, even though the manufacturers did not actually know of its evil character at the time. Again, suppose that hospital authorities treat a patient negligently. They are liable even though they gave their services gratuitously. If they gave him food which through their carelessness has been mixed with some injurious ingredients, are they also not liable even though they did not know of its injurious character? There is no difference in principle between such a case and the case where the driver of a car gives a friend a lift. 4. Ultimate consumer or user. Ultimate user is anyone foreseeably harmed by the defective product. In Stinnett and Hancock, the owner of a lorry took one of the wheels of the vehicle to a motor repairer with instructions to reassemble it. The defendant did it. While driving it, the flange came off and injured the plaintiff. It was held that the plaintiff was an ultimate consumer, and so by manufacturing a product negligently and resulting in injury to the plaintiff, he was liable. Branton J. held that in this case, as in that case, there was an operation performed by a man who must have known, had he considered the matter for a moment, that it was an operation which, if he did not perform it properly, would probably result in injury to somebody upon the road. He knew that the lorry was being repaired for the purposes of being used on the road. He knew that if it was not repaired with due care, with this wheel so assembled as to make it keep together and not fly apart upon the road, in all probability somebody would be injured as the result of his not having done that which he should have done. He knew that the second defendant was not going to take the wheel off or submit it to any scrutiny to see whether the work had been properly done. Therefore, it seems to me that every element which was considered by the majority of the House of Lords in Mallister or Donoghue and Stevenson to be necessary or render the maker of the article in that case responsible to the ultimate user of it was damaged thereby is present here. This case also supports the point that the ultimate consumer could include bystanders. 5. No responsible possibility of immediate examination. Lord Thankettin in Donoghue and Stevenson laid down the test for determining whether there was no responsible intermediate examination of the product, and these are: A. Whether the manufacturer contemplated that any defects will remain there at the time of their use by the plaintiff. See Hawks J in Dransfield and British Insulated Cables. B. If a consumer detects the defect but uses the product, the consumer might be held to be contributory negligent. See Rimmer and Liverpool City Council. If the consumer misuses the product in an unfashionable way, the manufacturer will not be liable. Thus, the consumer must use the product exactly as it left the manufacturer and use it as it is intended to be used. See Aswan and Lupdine. C. The mere opportunity for inspection after it has left the manufacturer will not be enough to exculpate the manufacturer. D. However, if the manufacturer gives a warning or instructions relating to use of the product, for instance, test before use, then this may be sufficient discharge of the duty by the manufacturer. E. A defect may be in the design, the container, labeling, or packaging. See Street on Tort, the 8th edition. See also Dransfield and British Insulated Cables, where Hawk J held that although the defendants were negligent in the manufacture of the ring, and such negligence was the cause of the accident, there was an opportunity for intermediate examination of the ring by the local authority, which examination would have disclosed the defect. The defendants, as manufacturers of the ring, were not therefore liable in damages to the plaintiff. 6. Want of reasonable care. It has been held that the burden of proof laid on the plaintiff to show absence of reasonable care on the part of the manufacturer. See Lord Macmillan in Donoghue and Stevenson, where he stated that the burden of proof must always be upon the injured party to establish that the defect which caused the injury was present in the article when it left the hands of the party whom he sues, that the defect was occasioned by the carelessness of that party, and that the circumstances are such as to cast upon the defender a duty to take care not to injure the pursuer. There is no presumption of negligence in such a case as the present, nor is there any justification for applying the maxim res ipsa loquitur. Negligence must be both averred and proved. It is worth noticing that under the requirements, one may plead res ipsa loquitur if the evidence allows it. See the cases of Lord Wright in Grant and Australian Knitting Mills, Lewis J. in Daniels and White, Abuaje and Kumasi Brewery Limited, where Janbo J. held that the authorities are settled in the view that the maxim res ipsa loquitur applies to the negligence in manufacture when the circumstances are such as to call for its application. And Overseas Breweries Limited and Achiampong, where Archer JA declined to follow Daniels and White, he emphasized that the duty of care exacted by the doctrine in Donoghue and Stevenson is not fulfilled by a manufacturer who succeeds in demonstrating that he has a foolproof system of manufacture. Notwithstanding his foolproof system, negligence will be inferred against him unless there is evidence that the defect in the manufactured article was probably due to causes for which he cannot be held responsible. 7. Preparation or putting up. The rule is based on the control of the production process of the product and also extends to distributors who are expected to test the products. In Donoghue and Stevenson, Lord Thankirton stated that it covered such negligence acts as occur in the actual manufacture of the products. He added that the manufacturer must be in control of the production process. See also Watson and Buckley per Stable J and Andrews and Hopkinson per McNair J. 8. Life or property. The injury must be to the consumer's life or property as well as economic loss. See Headley Byrne and Heller Partners. See also Candler and Crane, Christmas and Co. Kindly note that now negligence does not only affect life and property but economic loss as well. It is important to take notice of the Sale of Goods Acts of Ghana, 1962 Act 137, Section 13, which provides another source of liability of a manufacturer. Additionally, the chattels in question under this tort may be dangerous and non-dangerous chattels. For this, see Dixon and Bell, where Lord Ellenborough CJ said, the law requires of persons having in their custody instruments of danger that they should keep them with the utmost care. The case of Heaven and Pender, where Cotton LJ said, anyone who leaves a dangerous instrument such as a gun in such a way as to cause danger, or who without due warning supplies to others for use an instrument or thing which is to his knowledge from its construction or otherwise is in such a condition as to cause danger not necessarily incident to the use of such instrument or thing, is liable for injury caused to others by reason of his negligent act. Dominion Natural Gas and Collins, where Lord Dunedin also said, what that duty is will vary according to the subject matter of the things involved. It has, however, again and again been held that in the case of articles dangerous in themselves, such as loaded firearms, poisons, explosives, and other things adjustem generis, there is a peculiar duty to take precaution imposed upon those who send forth or install such articles when it is necessary, the case that other parties will come within their proximity. The duty being to take precaution, it is no excuse to say that the accident would not have happened unless some other agency than that of the defendant had intermeddled with the matter. In the case of Langridge and Levy, where Park B said, if the instrument in question, which is not of itself dangerous, but which requires an act to be done, that is, to be loaded in order to make it so, had been simply delivered by the defendant without any contract or representation on his part to the plaintiff, no action will have been maintainable for any subsequent damage which the plaintiff might have sustained by the use of it. But if it had been delivered by the defendant to the plaintiff for the purpose of being so used by him, with an accompanying representation to him, that he might safely so use it, and that representation had been false to the defendant's knowledge, and the plaintiff had acted upon the faith of its being true, and had received damage thereby, then there is no question but that an action would have lied. Concluding, when answering a question on this tort, you are therefore required to state the old position and contrast it with the current principle. Then you lay down the 8 elements or requirements rising out of the principle as we have concisely done here. This is the end of our 14th episode, and we hope you were able to study with us. Please do well to join us for our subsequent episodes. We seek you to subscribe, like our videos, write your comments at the comment section below, and help us share this channel to everyone. Thank you.